the petitioners wish to reserve any rebuttal time, please let us know that when you start, before you start your argument. I want to make sure that everyone understands to put your cell phones away, as I put mine on silent right now, and my Apple Watch too, so please do that for us. I want to make sure that everyone understands that the court is not deciding the merits of this case or these cases this morning. Our task is to answer these 4 certified questions that were certified to us by the U.S. District Court. And I'm going to read those just real quickly here. And when I say TSCPA, I mean Tennessee Silica Claims Priorities Act. Are the requirements of the TSCPA an affirmative defense that must be pleaded in a responsive pleading, or are they prima facie requirements which can be raised at any stage of litigation? Do the TSCPA's requirements apply to all cases involving exposure to silica or mixed dust, or if coal ash is silica or mixed dust within the meaning of the TSPCA, are plaintiffs' claims exempted from the TSPCA's requirements because they are raised under the common law? Question 3, does coal ash, which contains silica, fibrogenic dust, and other components that may cause injury but are not fibrogenic dust, constitute, quote, silica, end quote, or, quote, mixed dust, end quote, such that the requirements of the TSPCA would apply in these cases? And question 4, if coal ash does qualify as silica or mixed dust, does the TSCPA apply even if plaintiffs' claims are based on injury resulting from exposure to elements of coal ash that are not silica or fibrogenic dust? Thank you for listening to that. And now we're ready to begin our case this morning. Mr. Hibner, if you'll call out the case, please.
Greg Atkinson et al. Versus Jacobs Engineering Group, Inc.
May it please the court, I'm Dwight Tarwater of the Knoxville Bar. I represent Jacobs Engineering Group, and if the court please, I would reserve 5 minutes for rebuttal. We're here on 4 certified questions sent over by Judge Barlin, all of which that relate to the application of the Tennessee Silica Claims Priority Act. These are personal injury cases, could be described as a mass filing of personal injury cases, alleging exposure to coal ash composed of silica and mixed dust during the remediation work at TVA's Kingston steam plant, secondary to the spill that occurred in late 2008. The answers to the questions are all in the statute. The statute is very clear, it's unambiguous, it's plain, and I brought some visuals, and I'm not questioning the vision, certainly, of the court, but it will—
That might be a fair question for some of us.
Yes, Justice Kirby, but this case is all about statutory interpretation. And so I felt like it would be helpful to all of us if we peered into this statute together to see exactly what it says and what the words say and how it applies to this case. And I will introduce my argument a bit by talking about the application part of the statute. Then I'll go through each of the 4 questions and tick off the answers to those one after the other, and I'd be glad to answer any questions as we. But when we consider application, we look at the application part of the statute. This is when the statute applies. There are 3 defined terms. Applies to all civil actions. I will talk more about that when we get to question 2, but all civil actions is defined broadly, at least as broadly or perhaps more broadly Silica cases, claims against bankruptcy trust, but in essence, it applies to all civil actions. Two other defined terms are silica claim or mixed dust disease claim. This is that to which the statute applies. So let's look at that and see how the General Assembly defines silica claim and mixed dust claim. And I would call the court's attention to how broad this language is. Incredibly broad language. Silica claim means any claim, technical difficulties here, any claim arising out of, based on, or in any way related to inhalation of, exposure to, or contact with silica. An spectacularly broad definition related to any inhalation claim, exposure claim, or contact with silica.
Mr.
And note the
Tarwater,
term- Yes, Your Honor.
sorry, I want to take you, if we may, to the definition of mixed dust and talk a little bit about that. I don't know if you've got that on a board that you want to put up.
And there are, and I'm assuming, Justice Campbell, you're asking about the definition of mixed dust as opposed to mixed dust disease.
That's right. I want to start with mixed dust.
All right, so mixed dust, as defined by the statute, means a mixture of dust composed of silica and one or more other fibrogenic dusts, capable of inducing pulmonary fibrosis if inhaled in sufficient quantity.
So let me ask you this. Is it your position that mixed dust in this case refers to or encompasses coal ash in its entirety, including the components of coal ash that are not silica or a fibrogenic dust?
Yeah.
Or is it your position that mixed dust is the part of coal ash that is the silica and the fibrogenic dust?
Yes, Your Honor. The answer to your question is that coal ash in its entirety that contains silica and one or more other fibrogenic substances is a mixed dust according to this definition.
All of it. So the
Yes,
whole
Your Honor.
thing is mixed dust,
Yes, Your
including the
Honor.
parts that are not that are neither silica nor a fibrogenic dust.
Yes, Your Honor, absolutely. And the reason for that is there will never be a perfectly pure exposure to anything, to the air that we breathe, or to the water we drink, or to the soil on which we walk. And I would say that a white cloud does not change the nature of a blue sky. And so there is no definition of partial mixed dust. There is no definition that would answer your question other than the definition of mixed dust, which we have here in number 13 in the definitional section, which would include all of the dust cloud. Yes, Your Honor.
How do you interpret the phrase composed of in that definition?
The way that I interpret it is well, composed means composed, but I would say that it has to include everything that's in the dust, not just the substances that are silica plus fibrogenic dust, because then there would never be a mixed dust the other way.
Well, I mean, isn't it possible that the definition is referring to the part of the substance that is the silica and fibrogenic dust? I mean, when I look up the definition of composed of in a dictionary, I mean, composed of is generally used to connote exclusivity. So, for example, the statute could have said mixed dust means a mixture of dusts including silica and one or more other fibrogenic dusts, which would be non-exclusive. Then you could bring in the whole thing. But composed of is typically used to connote exclusivity.
I would agree, but it would, in this situation, I don't see how the definition of mixed dust could exclude the components of the dust that are other than these fibrogenic dust.
Let me
There would never be.
let me follow up on that question though, Mr. Tarwater.
Yes, Your Honor.
And if you would stand by the microphone, because we are live streaming this, so that people will be able, on the live stream, will be able to hear
Yes,
your
Justice
answers.
Kirby.
I understand you're a natural trial lawyer and you want to pace, but the original legislation was proposed by, I guess it was an industry group, I'm not sure, ALEC is the acronym for it. And the original model legislation that Tennessee adopted was silica-centric, asbestos and silica, but mainly silica-centric, and everything revolved around diseases that were caused by the silica. So when it got to Tennessee, as I think you pointed out in your brief, Tennessee added this mixed dust, silica and mixed dust. According to your interpretation, that expands the reach of the statute enormously. I mean, breakfast cereals contain silica. Motrin contains silica. If I eat a breakfast cereal and my claim is that it had ground glass in it, according to your definition, it would, I think I would be completely precluded from immediate injuries that took place. So what is it about Tennessee's addition of mixed dust that points us toward that kind of expansive view of the reach of the statute?
Yes, Justice Kirby, you are absolutely correct that the original legislation, the model legislation, was directed at mass filings of silica claims. Tennessee then expanded that to also include mixed dust claims. And the reason for that is the General Assembly sent a clear message that mass torts were mass filings were a concern. Those minimally injured were a concern. Those questionably exposed were a concern. And they wrote the statute extremely broadly. Now, we're a long way from the hypothetical that you just asked me about.
Certainly it would apply.
Well, it
Under
would.
under your interpretation, would it not? If I take Goody's headache powder, and I say it gave me a brain aneurysm and it contains some silica, then according to your interpretation, this is a huge expansion, and for the statute to be interpreted that expansively, and you didn't even notice it for 7 years, and nobody apparently has noticed it, it just hasn't bubbled up in the appellate courts. What am I missing?
Your Honor, I can answer that, but it's going to be a bit of a longer answer, a direct answer with an explanation. First, we have to look at how the legislature defined mixed dust disease claim. And they defined that in such a way that it would actually encompass the example that you just gave. That's how broadly they wanted it. They wanted the statute to reach, or at least that's how broadly they wrote it, probably not figuring there was going to be a Motrin claim, but probably figuring that there would be claims that would be encompassed by this act that would be in any way related to mixed dust, and it even uses this term, contact with mixed dust. And the application part of the statute, which is 309, makes the statute applicable to exposure. So it's based on exposure. It is written very broadly. It's a long way from the Motrin example, but clearly when you have this type of exposure, 40 to 60% silica, asbestos, beryllium, which
You
brings
understand,
it,
we have to consider how it would apply in other cases that are not before us. And it strikes me that the interpretation that Justice Campbell was asking about would not lead to the kind of questionable results that I've been describing to you. And we have to keep in mind those other scenarios where it could arise.
I quite agree, Justice Kirby, but I would also point out that the words of the statute are the best we know about what the legislature intended to pass. And if there is a disconnect between how this should be applied in the Motrin example, then I would heartily suggest
that came up in your brief, and you didn't. I didn't see a shrug emoji in your brief, but it was like that. It was like, oh well, that's what the legislature wrote, and I'm not sure that that is consistent with how we should interpret it.
I'm the shrug emoji gives me brings a smile to my face because I'm not sure what that is, but I would I do know what the words of the statute say, and I'd like to answer your other question about
Please.
waiting 7 years and that
Yes.
kind of thing. This was in a unique procedural posture, a very unique procedural posture, and case-specific discovery was not open until 2020. And as soon as we determined that the prima facie requirements of the Act could not be met by numerous of the plaintiffs because they cannot show the impairment, they cannot show the X-ray changes, and they don't have the appropriate latency period, we moved for summary judgment. We moved for summary judgment before that the discovery was even over, and so it's not that we waited. We waited until we knew that the cases could be resolved on the merits. Jacobs could have raised back in 2014 or 15 when the cases first were filed, could have filed a Rule 12 motion for the failure to provide the reports from a competent medical authority.
Mr. Coldwater, let me interrupt you a minute.
Yes, Your Honor.
I want to talk about 2934, 304, and 305. It's not up there, but this is dealing with the requirements after 120 days from the filing of the complaint. The plaintiff must file a written report making out the prima facie case.
Yes, Your Honor.
Of course,
I have the first part of
Well-
2934, 304, the prima facie part of the statute.
once that is done, then, of course, that triggers requirement on behalf of the defense to file something challenging that application, whatever you want to call it.
Yes, Your Honor.
Of course, was that done in any of these cases?
The reports were never filed,
Okay.
so the clock never started on the 120 days.
Is it your position because those reports were never filed that the defense had no obligation whatsoever to do anything in response?
Well, it was optional at that point. It could have been raised, and if the reports were filed and they were not challenged within the 120 days, then that in and of itself might have be considered a waiver. But since the reports were never filed and the Rule 12 motions were never filed, 305 doesn't apply.
But
in
Mr.
these
Tarver, let me
cases.
follow
Yes, Your
up on
Honor.
that if I may, though. But when we look, I mean, when we're talking about the words of the statutes and how broad the statute is, the legislature clearly set up a procedure, and a somewhat extended procedure with 120 days versus 30 days for an answer or things like that, for filings to take place. I mean, isn't it a logical interpretation of the statute to say that once the plaintiff has not complied with that 120-day provision with regard to establishing the support for its prima facie case, that then that triggers the 120 days for the defendant to file that? Because otherwise, we're in a situation, so if we follow your position to its logical conclusion, and in this case may be a great example of it, your client could be raising this 10, 20 years down the road.
Yes, Justice Bivens, the statute specifically says that once the report is filed, the clock starts. But the statute also says, no person shall bring or maintain a civil action. And this is in the prima facie evidence section of the statute. And the prima facie evidence section of the statute sets out the prima facie requirements that can be raised at any time. And if plaintiffs don't prove their case, they don't prove their case. But actually, Justice Bivens, 29305, the report provision, is not even at play here, because the reports were never filed. So, and then the Rule 12 motions were never filed. And the thinking, I think, I was not there then, as you know, but I think the thinking was that a resolution on the merits is much more preferable than a Rule 12 motion, which would be a dismissal without prejudice, according to the words of the statute.
Well, the remedy for this statute is, if it's dismissed, is without prejudice as well, is it not?
Your Honor, no, I don't think so. We have motions for summary judgment based upon the prima facie requirements of the statute that go far beyond the competent medical authority. It's the latency period, the exposure requirements, the failure to meet the impairment rating requirements. And if these cases were...
But I think Justice Bivens is talking about 305B.
B, yes.
305B.
That specifically says that the dismissal is without prejudice. I think the statute seems to be written that aimed at plaintiff harvesting by big firms and bringing in a lot of plaintiffs who may have been exposed to silica but hadn't developed any permanent impairments yet. So it allows the plaintiff specifically to come back if he or she develops a permanent impairment and refile with the appropriate documentation.
Doesn't really put a time limit on refiling with sufficient evidence. So does that really make sense here to say you're successful and you get all these cases dismissed, they can just refile with different paperwork essentially?
I mean, obviously, they'd have to file the medical affidavit and things of that nature, but it does seem to be that it would be without prejudice.
Yes, Your Honor, and perhaps I misunderstood the question, but I agree with you that if the report from a competent medical authority is not filed or is inadequate and is challenged, that results in a dismissal without prejudice, and the case can be refiled. I agree with you, and that's what 305
So you're
says.
distinguishing between a lack of a prima facie case generally under 304 versus the specific provisions of 305 dealing with the supporting evidence.
Exactly. They are two separate sections, and they operate in different ways. And the prima facie requirements under 304 are related to impairment, to x-ray changes, to pathology changes, to exposure, to work history, to latency, to those kinds of things. And that is what prompted the original motion for summary judgment.
So that's what you're traveling on 304, rather than
304,
305.
Exactly, Your Honor, absolutely.
Now, you mentioned earlier several times legislative intent, and in this statute, it's a little bit unusual in that an entire subsection or section is devoted to legislative intent, 29, 34, 302, and throughout 302, where the legislature declared its intent and the purpose of this statute. Silica is mentioned many times, but exposure to silica, injury by silica, but mixed dust is never mentioned, is it?
Not in that section of the statute. Of course, it is mentioned.
It is later.
Later,
right.
yes, Your Honor.
And if you read 302, it does appear to be a remedial statute for the benefit of the plaintiffs in some ways, because, for example, Part E2 is the purpose is to fully preserve the rights of claimants who were exposed to silica, so they can pursue compensation should they become impaired in the future as a result of exposure. And then later it says to provide access to the court system for those who are actually physically impaired. And you hone in on that language, I'm sure. Impaired by exposure to silica. No reference to mixed dust, but it does appear to say we want to give these people who are harmed by silica access to our court system so they can be compensated. But I guess what I'm reading here is sort of almost a gotcha to these plaintiffs. In other words, you didn't file this on time, therefore we got you and your case will be dismissed. How do you square your position here with this legislative intent, which appears to be remedial?
Yes, Justice Lee. The concern at the time was the mass filings of silica claims and asbestos claims and other types of claims, and including mixed dust claims. And the idea was that the resources should be preserved for those who were truly deserving.
Did that crisis ever really happen
Yes, Your Honor.
with asbestos cases? With
With the silica cases,
Yeah, okay.
and I will get you the site when I get back up for rebuttal, but there's an opinion by Judge Claudia Jack in Texas that dealt with the fraudulent silica filings, and I can, and not that these are fraudulent filings, but they are not able, in many instances, to meet the prima facie requirements of the statute. So if the statute applies to a silica claim, if this is a silica claim, 60% silica, or a mixed dust disease claim, which is defined by the statute as Justice Campbell and I were discussing, then the statute applies.
Thank you, Mr. Tarwater. We appreciate it.
And I see my time is gone, so I will go back to my table. Thank you, Your Honor.
May it please the court, my name is Mark Silvey. I'm from the Knoxville Bar. It is with great interest that I've listened to the court's questioning today because the court understands the exact problems that we've pointed out and that we've identified in our briefing. Is Jacobs here seeks to have this court give an overly broad interpretation to a statute that is very limited and very well defined in its scope. Why is it doing that? It seeks to have this court shield it through its interpretation of a statute that it should have raised even if it was applicable, and we don't concede that, many years ago, to shield it from responsibility for turning an environmental disaster into an occupational disease disaster that is as tragic as it was avoidable. Silica is what the Tennessee Silica Claims Priority Act is about. Make no mistake, it's a very specific statute, very directed at a very specific type of illness. When silica fibers like asbestos, and I know the court is familiar with asbestos, when those fibers are airborne, they have little sharp edges. They get trapped in your lungs. The body, in reaction to that, creates scar tissue around those pieces. When it lasts long enough, it impairs lung ability, it impairs a person's ability to breathe, and they develop fibrogenic diseases, silicosis, mixed dust pneumoconiosis. These cases aren't that. If you look through our briefing, you'll know that the proof in this case is that none of the illnesses that these workers are seeking relief for are silicosis, or mixed dust pneumoconiosis, or lung cancers that result from silicosis or mixed dust pneumoconiosis.
If we can interrupt just for a moment, I'd like to take you to the definition of disease claim, either silica disease claim or mixed dust disease claim. Can you tell me what in the text of those definitions, which are seemingly pretty broad, limits the claims to those alleging injuries caused by these diseases that you mentioned, the fibrogenic diseases? What in the text of those definitions are you relying on for your argument that it only applies to those sorts of diseases?
That is a great question, Justice Campbell, and there is nothing in those definitions. And that's what Jacobs wants you to focus on, like you heard it mentioned in its briefing, the West Virginia case, where a West Virginia court interpreted an Ohio statute to cover diseases that were neither silicosis or mixed dust pneumoconiosis or lung cancer resulting from. If you look at that case, and if you look at what Jacobs wants you to do here, they want you to, they took the poster down. They want you to consider that definition in isolation. And our position is, and I was trying to figure out on my way driving out here how to make the court understand this, trying to come up with the magic words. And I don't need to, because Justice Page wrote them for me. In the Kaufman case, which this court issued last year, in a case concerning the TPLA, where the petitioners wanted a particular section of the TPLA to be interpreted very broadly, Justice Page said this at page 897 of the opinion: "We decline to read section 2928-108 in a vacuum, as appellees suggest. In interpreting statutes, we are required to construe them as a whole, read them in conjunction with their surrounding parts, and view them consistently with the legislative purpose." Thank you. I couldn't have said it any better. What Jacobs wants you to do is to look at the definitions section, 303, read these very broad, as has been pointed out, very broad definitions of mixed dust disease claim, of silicosis claim, and there's nothing else to see here. That's all you have to look at. And our position is that you can't do that to understand the intent of the statute, because if you read the remainder of the statute, both section 302, that's the legislative purpose, section 304 that describes the pathological evidence that's necessary, the radiographic evidence that's necessary, the pulmonary testing that's necessary to establish the prima facie case, you'll see that it only relates to interstitial lung diseases, where your ability to inhale, your ability to breathe is impaired because of the formation of scar tissue as a result of inhaling silica.
But if we look at section 302, the section that details the legislature's intent, I mean, isn't it true that part of the legislature's intent was to prioritize certain kinds of claims?
Oh, absolutely it is. And it is correct to note that statutes of this type were enacted to dissuade attorneys of questionable morals from ginning up lawsuits that were illegitimate. Mr. Tarwater was correct. There was indeed, in days of yore, a problem with people who would go to drive-up X-ray clinics sponsored by attorneys and create what were essentially, it looks like to me from reading the literature, Xeroxes of X-rays and saying, okay, this is it, this shows you've got a problem, file your claim. What these statutes were created to do was to deter people from doing that, and so was to deter people from doing that while preserving legitimate claims of silica-related diseases. Again, none of these are silica-related diseases.
Well, let me follow up, if I might, on Justice Campbell's earlier question. Of course, we read the statute in context. We always do that in interpreting statute. But what language do you say we are interpreting specifically to get to the result that you are advocating?
When our position
Because we don't
is-
just wave our wand over the whole statute. We are interpreting particular language.
Sure. If you read the Section 303 definitions of mixed dust disease claim, silicosis claim, in isolation, they are very broad. But when you look to see then, all right, anything, anywhere, anytime that involves a person who inhales, is exposed to, or contacts silica, those are the claims. That's the definition. But then you look to Section 304, and specifically, let's look at 304. A3, that's for non-malignancies. A diagnosis by a competent medical authority that has both evidence of a permanent respiratory impairment rating of at least class 2, means the lung capacity is impaired. Again, it's related to breathing, silicosis, respiratory disease, a fibrogenic disease, and A3B, 304A3B, the exposed person has a silicosis or mixed dust disease based at a minimum on radiological or pathological evidence of silicosis or radiological or pathological evidence of mixed dust disease. Then you have, because again, this is a complex statute, then you have to go back to 303 and look at what those evidences are. And if you look at 303.17, it tells you that pathological evidence of mixed dust pneumoconiosis means a statement by a board-certified pathologist that more than one representative section of lung tissue involved with any other disease process demonstrates a pattern of, and I'm going to butcher these medical terms, so forgive me, parabronchiolar and parenchymal stella star-shaped nodule scarring.
Say that again real fast.
You actually did pretty well.
Three
on that.
times.
So, Mr. Sylvie, are you essentially saying that because of this exposure to coal ash, there's just no way the symptoms or the diagnosis, whatever, fits within this statutory definition to
That's
prove
correct.
exposure to silica?
That's
right?
correct.
Because
The-
if you take just Section 304A, it says you've got to prove by competent medical proof that the claimant was exposed, that that caused a physical impairment, and that the exposure was a contributing factor. Well, let me go back. You had the exposure, you have physical impairment, and that exposure was a contributing factor to that physical impairment. Now, I take it you can prove that in your cases, correct? Those are basic court requirements of an injury case.
Oh, absolutely. But let me put two sharper points on that.
Okay.
Number one, it's a substantial contributing factor. And that's one of the whole reasons these statutes were enacted, because it changed the standard from a relation to.
With a reasonable certainty?
Yes, yes.
So it raised the bar.
Yeah, it raised the bar.
All right.
And second, we can certainly show that for each of the diseases that are alleged in this case, but that none of them stem from exposure to silica. It's not the fibrogenic component of silica that exists as a part of coal ash. That's the issue here. It's the mutagenic particles. It's the radioactive particles, arsenic, lead, we've outlined them in our brief, I think radium-226 and 228 exposure. That's the stuff, for lack of a better word, as Justice Campbell was talking about, that coal ash is composed of, in addition to silica. These aren't silica claims. And so it's an excellent point because you have to distinguish between silica claims, which is what this case is not about, and the statute, which is what the statute is about. It is a matter of medical proof, and Justice Bivens' question about whether you could simply generate your report. If you had to dismiss, and if you came up with the reports later, you could refile the dismissal was without prejudice. That's true. But again, reading the statute as a whole, that provision of 305 doesn't help us, because these aren't illnesses that involved star-shaped stella in the bronchial tubes. These aren't cases that involve the kind of proof that you have to show for a silica disease. They're leukemias, contact dermatitis, COPD, peripheral neuropathy. There are about 10 of them. We identified all of them in our briefing.
The language in the statute on the definition of mixed dust and mixed dust disease or claim, I can't remember what it's claimed, is quite broad. So, and does not indicate necessarily inherently limited to silica. So, are you saying then that we have to go over to the evidentiary definitions?
Yes, Justice Kirby.
How does that get you the limitation that you?
Because if you, to read the statute for it to make any sense, and the best statement on that, David's reply brief. On page 17 of their reply brief, they say, and I will quote, "The only reading of the Silica Act consistent with its actual terms is that plaintiffs are required to provide proof of fibrosis separate from the disease they are claiming. What possible reason would the legislature have found it necessary to require a plaintiff to prove a disease they don't have and aren't making a claim for?"
Mr. Silva, you're saying if you can prove that the disease, whatever it is caused by arsenic, for example, it doesn't really matter that there was some exposure to silica also?
That's precisely what we're saying, Justice Page, because that's the only, I hate to sound like Mr. Spock, that's the only logical deduction that you can make from reading this act as a whole. And we know, because of the canons of statutory interpretation, which again you kindly laid out for me in the Kaufman opinion, that this court has to read statutes to try to harmonize their parts.
Let me ask a question. I'm going to ask Mr. Tarwater to address this when he comes back up. But we've had a phase 1 jury trial in this case, right?
Correct.
And Judge Varlin sent interrogatories to the jury and asked 3 questions that were answered. Whether Jacobs violated his contract with TVA, whether Jacobs failed to exercise reasonable care in carrying out the duties owed to plaintiffs, and whether any such breach was capable of causing each of the 10 medical conditions. They answered yes to all those questions. What impact, I'm asking you, does that have on the 4 questions we're answering today, if any?
It does. That's, again, it's the fundamental nature of this case that we have to determine whether a statute, that you have to determine whether a statute specifically directed at silica-related illnesses nonetheless sweeps with a broad enough brush to cover those 10 things that Justice Varlin queried about on the jury form that you can't prove within the confines of this act. Again, let me give you another example. In this case, one of the claims is for Miss Jean Nance. Miss Jean Nance was a lady who worked in the office out there. She wasn't out in the coal ash every day, but they would track it through. She was in the office. She worked there 2009 to 2013. In 2015, she was diagnosed with an aggressive form of leukemia. She died shortly thereafter. There's no way that we would ever be able to develop proof that would fulfill the requirements of a cancer-related illness under Section 304. They say that in their brief. That's what they argue in their opening brief, is that Jean Nance's case just gets dismissed. She's just out because she can't show radiographic proof of a fibrogenic lung disease. That can't be what the legislature intended, particularly in light of the fact that its stated purpose was to allow greater access to the courts for people with legitimate claims of silica-related injuries, not leukemia, not contact dermatitis, not COPD, not peripheral neuropathy. It is directed at a specific type of illness that was subject to abuse. People with leukemia weren't included in that abuse.
Mr. Silly, let me, I just want to clarify your position on what the statute covers. So would you agree that if a plaintiff alleges some sort of injury that is not a fibrogenic disease, but the plaintiff alleges that that injury was caused by either silica or mixed dust, so not the other stuff, as you put it, would you agree that the statute covers that?
If the disease that is claimed is one that would be provable by the type of evidence that's necessary under the statute, under Section 304, then it would be covered.
But isn't it true? I'd like to go back to my point earlier that, part of the legislature's intent here was to prioritize certain kinds of claims. I mean, by prioritizing some claims, isn't the legislature necessarily deprioritizing others or precluding plaintiffs from recovering from other, or making it at least more difficult to recover from other sorts of claims? I mean, and why wouldn't these other kinds of claims that are based on exposure to silica or mixed dust, but maybe are not fibrogenic diseases, just fall into that category?
Because, again, it's a Mr. Spock thing. It wouldn't make logical sense for the court to say that, no, one type of cancer takes priority over the other.
Well, it wouldn't be, I mean, it would be the legislature saying it.
It is not, that would be what we would say would be an unreasonable interpretation of the statute. The priority that they talked about in 302 and through the history of all these type of acts, legislative acts, is prioritizing legitimate claims of silica-related injuries over those type of questionable claims that have been being ginned up by unscrupulous lawyers for years. People who come in and say, well, yeah, I worked in sand, and they give you a Xerox of a lung x-ray and send you on your way to make a claim. What the legislature wanted to do was prioritize the claims of people who actually had reduced lung capacity, people who actually had lung cancer stemming from the fibrogenic quality of silica crystals.
Well, let's be real, though. Some of this statute, it contains limitations. It's a trade-off. They wanted, for silica-related diseases, these plaintiffs were allowed the limitations period would only run from discovery of a permanent impairment. That's an unusual, that's an extension, and that would override any kind of statute of repose, any of that.
Agreed.
But in return for that, they have to meet the specific requirements. So do you have any plaintiffs who are seeking relief for a condition caused by silica?
No.
Okay.
The only way that you could theoretically say that that was accurate is that some of the claims are based, and you'll read about this in the briefing, is based on what's called PM 2.5, particulate matter that's smaller than 2.5 microns. But if you read, and believe me, I've waded into the medicine on this, I know much more than I ever wanted to know about it. If you read the medicine on that, the mechanism of injury for that is different. So it's not the fibrogenic quality.
Without getting into the weeds on that, would you agree that if a court found that one of your plaintiffs was making a claim for an injury that is caused by silica, that would be subject to the Act?
If the court, because again, some of these cases have been stayed, if at some point later on, one of the people developed a silicosis or a
I
mixed
mean, we
dust
don't have to
pneumoconiosis.
get down into the weeds on the particular plaintiff's claim. We get to, at some point, boot it back to the federal district court
Sure.
to sort that out.
Sure. But if that claim did arise and it was susceptible to proof of the kind described in Section 304, then yes, certainly the Act would apply.
Okay.
Because again, that's the kind of claim it was directed at, absolutely. But for claims that aren't susceptible to the kind of proof that Section 304 and the Act itself require, it would be, again, illogical to expand the TSCPA to sweep within its broad scope those kinds of claims. Your example, Justice Kirby, about the Motrin or the Tylenol, whatever it was great, but there are tons of those, because if you read 303 and its definition of mixed dust disease claim, and mixed dust disease is never defined, only mixed dust disease claim. What is defined is mixed dust pneumoconiosis, which again is an indication of what the legislature was aiming at. But if you read it literally, mixed dust disease claim means any claim for damages in any way related to contact with mixed dust. So they have said in their briefing, Jacob says in their briefing, that silica is present in all kinds of building products like concrete, in addition to coal ash. It's in concrete. So if I'm walking down the street by a construction site and somebody knocks a bag of concrete off a building and it hits me in the head, that is a claim for damages relating to contact with a mixed dust. Is that what's meant to be covered by this? One of the associates at our office said, if you're walking through a big box store and one of those little silica desiccant packs falls out of something, breaks, you slip in it and fall down. That is a claim for damages in any way relating to contact with a mixed dust, or in that case, silica. It also can be read to say a mixed dust disease claims mean any claim relating to damages in any way related to exposure to mixed dust. What does exposure to mixed dust mean? If someone is working in an office, and again, I wrote some examples down. If you're working in an office or a building where there are fumes from like a painting at an auto body shop, and those fumes themselves can be toxic and cause some sort of respiratory distress. But they also sandblast the cars to take the paint off before they repaint them. Is that an exposure which would trigger this statute? If you make a claim having nothing to do with that, but arising from whatever fumes, and again, I don't know, but whatever fumes arise from painting, would that be it? Some of the associates in our office have young children. I am led to believe, I don't have kids, I am led to believe that diapers contain silica desiccant to make them more absorbent. If there was some sort of claim that could be brought on a product liability basis for irritation or something that results from diapers, from disposable diapers, would that necessarily fall under the auspices of the Tennessee Silica Claims Priorities Act merely by virtue of being exposed to silica in these diapers? If you follow Jacob's line of thought, its line of reasoning, there is virtually no kind of claim that would be covered, that would not be covered by the Tennessee Silica Claims Priorities Act. Now, Mr. Tarwater's a smart man. He's going to get back up here and say, oh, that's not what we meant. We don't mean that Tylenol. We don't mean the Motrin. We don't mean diapers. But if you read the act in the way they want to, there's no way to rule those out. And that's all we're asking the court to do, is to read the statute as a whole, interpret it in a way that makes logical sense when it's read as a whole. It appears that if you do that, the very large definitions, the very broad sweeping definitions that you talked about, Justice Campbell, are meant to allow legitimate silica claimants to have access to the court, that you don't have to simply have inhaled it. If you've done something where you've worked in it or around it, and you can't show that you necessarily inhaled it every day, but that you develop a silica-related disease, a pneumoconiosis, a silicosis claim, then you should be entitled to try to pursue that if you can provide the requisite radiographic or pathological evidence. It can't logically be interpreted to say that if you are murdered by someone who hits you with a brick that's got silica in it, that you can't bring a wrongful death claim as a result of that intentional act because you can't show that you have radiological evidence of fibrogenic disease. That just doesn't make sense.
Well, but doesn't the definition of mixed dust also limit it to substances capable of inducing pulmonary fibrosis? A brick getting hit, I mean, a brick wouldn't cause pulmonary fibrosis, would it?
Oh, absolutely. No, I would hope not. But again, if you read in isolation the definition of mixed dust disease claim or silica claim, it is broad enough to cover that brick. So again, this court has to find a way to be able to provide guidance to those of us litigating these kinds of cases. And if you interpret the statute in the way that Jacobs wants, the question becomes, will it be necessary on the front end of a lawsuit for me to have a disclaimer at the bottom that says no silica was involved in this tort? If, as what they've talked about with Justice Kirby and Justice Page, they can bring it at any time because it's a prima facie claim, it's a prima facie evidence requirement, they can bring it at any time. Can they wait years and years down the road and say, oh no, we found out that there was concrete at that work site, we think you were exposed to silica, now you've got to prove that you had a fibrogenic disease.
Mr. Sylvie, let me, on that point, let me ask you a question. I think Jacobs argues that the question of, whether they waited too long to raise this argument, whether you view that as a waiver or, something that would involve principles of estoppel or latches, that is a federal, because this case arose in federal court and it's only to us on a certified questions, that question of delay is a federal question. Do you agree with that?
The question of whether it's a difference between void and voidable. If it's a question of waiver, yes, that's a matter of federal procedure. If it's a question of whether it's waivable, I think that's something that this court can decide. Is this the type of, is interposition of this type of statutory defense requirement, is interposition of that an affirmative defense or a matter that must be raised early on in the lawsuit? I think you can say yes or no, it is. Whether it should have been is a question for Judge Borland, but you can say whether yes or no, it falls into that category.
So if you prevail today or whenever the opinion comes out, how does that affect your lawsuit? How does that affect your burden of proof?
Not at all. If the court finds that the scope of the Tennessee Silica Claims Priority Act is limited to the types of fibrogenic diseases that can be proven through the Section 304 evidence, then it doesn't affect our claims at all, at least the ones that are pending right now. Again, somebody may develop it later on, but for right now, it doesn't affect it at all. The only way that it affects it is if the court says that, no, this act covers everything, anywhere, anytime. I see that I've got about a minute left, and there were a couple points that I wanted to make sure.
Let me ask this then, if we decide the act does apply, are your claims dismissed?
Yes, because the nature of the claims in this case are not fibrogenic diseases. The kind of evidence that's required to be shown under Section 304, whether it's a malignancy, a non-malignancy, or a cancer, a wrongful death, is not present in these cases.
So you're saying you cannot comply with this statute if it applies at all?
Correct. Because Jean Nance's case, her leukemia, she didn't have fibrocystic lung disease, fibrogenic lung disease. She can't prove that. People who have hypertension don't have the type of lung x-ray that's going to be necessary to show this. And so again, it doesn't make sense, as Jacob argues, for us to be able to pursue any of these claims that we want, as long as we also can prove a fibrogenic disease. That just doesn't make sense.
You can sum, I got you off track, you're getting ready to sum up.
No, it's just that's just it. We asked the court to view these issues, and again, it's important that we get guidance from the court on this because this will come up again. And they'll close with this, and I know I'm out of time. These sets of cases that we're on here today are a initial set of cases. We need guidance from the court because if the scope of this act is not decided today, we will be up again because Jacobs will raise this again. And for these cases and Tennessee jurisprudence as a whole, we need to have a clear vision of what the scope of this act is.
Thank
If there are
you,
no
Mr.
other
Shelby.
questions.
Thank you.
Thank you all very much. And thanks for doing this live as opposed to doing it on the computer. I'm old school. I would much rather be here. Thank you so much.
We're glad to be here too.
Yes.
So, Mr. Tarwater, if somebody gets hit in the head with a brick, are you going to argue the Silica Act claim? Act?
Your Honor, I heard those examples like you did, the brick and the diaper. This is a case about an exposure to a substance that's 60% silica. And they're talking about bricks and diapers? So if they have a question about the scope of the act, then that should be addressed to the General Assembly, not to this court. The words say what they say, they mean what they say.
Mr.
And
Tarwater,
there-
can
yes, Your
Can
Honor.
you offer any limiting principle as to why this statute wouldn't reach those examples that were offered?
Justice Campbell, the statute doesn't say that. I mean, the words of the statute are broad. So would it apply to the brick situation? I probably not from just a common sense standpoint. But the words say it would. The words say that it's to be interpreted broadly. The words say it applies to any contact with, any inhalation of. And when
Well,
I
let me
heard
ask it this way, I guess, just to pin down your position and clarify it. So you would agree that if there is an injury that is caused by something other than silica or a fibrogenic dust that just happens to be part of something that does contain silica and fibrogenic dust, and that causes an injury that isn't caused by silica or fibrogenic dust, and a plaintiff brings a claim related to that, that is covered by this statute. Is that what you're saying?
Yes, Your Honor, and let me tell you why. First, that's what the statute says. But in this case, if the plaintiffs were injured by exposure to these trace metals that they claim now that have harmed them, they would be able to meet the prima facie requirements of the statute because they would have been exposed to silica at levels scores of magnitude higher. For example, the arsenic example that I think Justice Page mentioned. Arsenic is present in coal ash at 200 parts per million, silica at 60%. So there's, 3,000 times more silica that
But I think Justice Campbell's question goes to which part of the coal dust caused the injury. That's what she's getting at. It's not the percentage of silica that's in the coal ash.
Yes, Justice Kirby.
So I'd like
and-
you to home in on that.
Yes, Justice Kirby, and it's about how 309 says the statute applies. And it says it applies to silica claims or mixed dust claims. And that encompasses whatever injuries are caused by the nature, the essence, the character of this dust, which is silica and mixed dust, we say. And
But the only way you get there is by construing mixed dust to mean all the other stuff too.
yes, Your Honor, that's true. And I thought about your question, which was very good. But does it compose mean include?
Well,
And-
no, my question was composed means the opposite of includes.
Yes, Your Honor. Yes, Your Honor.
Yeah.
That's what I meant. But I will tell you that question's been answered. And I realize it's not controlling, but the West Virginia Court of Appeals, which is their highest court in the land, considered that very question, holding that coal ash is a mixed dust
Did
under
they
the
actually
statute.
construe composed of? Did they look at, what does composed of mean? What's the definition of that?
The statutes are almost identical,
But
almost
did they
identical.
expressly address that?
They did not, they
piece
did not
of the
address,
definition?
I'm sorry.
No, I'm sorry, go ahead.
They did not address compose versus include. Okay? They did hold that coal ash is a mixed dust under almost the identical statutory
Mr.
language.
Tarver, before you close, do you have a response to the question I asked Mr. Sylvie about the fact we've already had phase one trial? Does that impact our consideration of these 4 questions at all?
In a way, I think it does, and I realize I have 1 second left, so.
I'll let you answer.
But if I could answer that question, I'll close with that. And I think we need to start out with what the claim is.
Short answer.
Short answer, okay. Part of that verdict was based upon fine particulate matter, right? And respiratory conditions, 2 or 3 of the conditions where general causation was decided related to fine particulate matter. Mr. Sylvie mentioned the fine particulate matter, we call it in the subculture PM 2.5, or very tiny particles less than 2.5 microns in length. So they filed their case and they allege they are harmed by silica quartz. Then they put on testimony about how much silica is in coal ash and how it's harmful. And then they call an expert to say it's the fine particulate matter, which was in the phase 1 verdict, which was the mechanism, which was the bad actor in the coal ash dust that caused their claimed conditions. And their expert says it's all the fine particulate matter, including the silica component. So the long answer to your question, which you told me to answer in a very short way, and I beg the court's indulgence on that, is that that part of the verdict does relate because it finds that that component of the silica dust is at play here.
Thank you, gentlemen, for those fine arguments, and we appreciate everyone attending today. These cases are very important.